I know of no jurisdiction in the world where it's not considered reasonable and appropriate for judges to make their views known in a proper way in relation to proposed legislation which actually affects the judiciary itself. There is little point in having a good court system likely to produce fair results in accordance with law if a great many people find it difficult or even impossible to access that system for practical reasons. A high priority must therefore, in my view, be accorded to questions relating to practical access to justice. But it has increasingly become the case that many types of litigation are moving beyond the resources of all but a few. There were, of course, systems which worked well in the past, such as the preparedness of the practicing professions to take on cases on the understanding that they would not be paid if they didn't win and secure an order for costs. While those systems still provide an effective means of litigating in certain areas, such as routine personal injury cases and some forms of judicial review, they can no longer, in my view, be considered as sufficient to provide anything like the full answer. There is a significant shifting of the burden of carrying litigation in common law countries onto the parties and away from the state. In civil law systems, the courts themselves, that is judges and judicial staff, carry a much greater burden of ascertaining the facts and researching the law. But that comes at a cost in terms of the much greater number of personnel who are required to staff courts in those jurisdictions. While it's not easy to address this question with any great precision, the numbers and cost are so glaringly different that it can certainly be concluded that the taxpayer contributes much less to the running of a court system in a common law country than does a counterpart taxpayer in a civil law jurisdiction. Indeed, in Ireland, the cost to the taxpayer is further reduced by the fact that court users contribute a significant proportion of that total cost of running the courts in the form of court fees. I think all who worked in the commercial court came to realise that a significant part of the reason for its success in being able to provide very quick, if not necessarily much cheaper, access to judicial decisions was the fact that significant resources were deployed. But the same level of resources cannot be made available to every part of the court system without significantly increasing the overall resources themselves. The existing system of judicial researchers and assistants has run into considerable problems, with significant difficulties in recruitment of suitable personnel and, importantly, their retention. However, a radical overhaul of the system has been approved by the Court Service Board as a result of a report by my colleague Mr. Justice Charlton. The Chief Justice is, of course, first and foremost President of the Supreme Court. When the Court of Appeal was established in 2014, a considerable amount of work went into formulating new procedures to streamline the process by which appeals were to be conducted in the Supreme Court. Indeed, in parallel, the Court of Appeal put in place its own new procedures. But it was always understood and accepted by the Supreme Court that it would be necessary to monitor those new procedures to see if they worked as intended and to identify any problems. Already some limited areas of the court process which are conducted either exclusively or very substantially online. Those areas will increase. Legislative measures are under consideration which will facilitate the filing of forms of sworn documents by online means. All applications for leave to appeal to the Supreme Court will be capable of being made and considered online. There was a successful experiment conducted in the recent past where an appeal was conducted entirely on the basis of all legal personnel and judges using only tablets. It is hoped to continue with the experimental use of paperless hearings. I do not think it's likely that there will be a sudden move which will have the effect of turning our court systems online overnight. Development is likely to be characterised by initial and gradual moves online in particular areas which lend themselves to the adoption of online procedures without too much complication. The criminal side of the work of the Court of Appeal is up to date. However, that achievement requires the allocation typically of 4 judges. The 6 remaining judges have to deal with an increased civil appeal burden. When one recalls that the Supreme Court in its former model had to deal with very few criminal matters given the existence of the Court of Criminal Appeal and still struggled with 8 judges, it is not difficult to see why there is a problem. It is also abundantly clear to me that the workload of the individual judges of the Court of Appeal is, if anything, beyond that which can reasonably be expected. The Supreme Court itself, of course, is currently down to 7 judges, one of whom is more or less full-time assigned to a tribunal, leaving an effective cohort of 6. Leaving aside altogether issues concerning the method of judicial appointment, there is an urgent need to address at least some aspects of the shortfall in numbers in the appellate courts as a matter of particular urgency. A final point on Brexit. The Irish Supreme Court plays its role in many Europe-wide judicial bodies, which are frequently consulted by the Commission and by European legislators. It is always necessary to ensure that the common law position is understood so as to minimise the risk of unintended consequences. In the past, we have to an extent been able to rely on the well-resourced United Kingdom to take the lead. Post-Brexit, Ireland will become the biggest common law jurisdiction, and a much greater burden will fall on us to ensure that European measures proposed fit well into the common law system.